If you get convicted of drunk driving in Michigan, the Secretary of State will take action against your driving privileges. So in this video, I explain what those consequences are for the three most common types of drunk driving convictions or charges. What I don't contemplate is repeat offenders, habitual offenders. That's a different story. Nor do I contemplate if there's a refusal of a chemical test. That also is a different story, and there are different consequences. For the refusal, I did a video on that. If you click the link, you can go to that if that affects you. So in this video, I will be going over those consequences discussed, several common misunderstandings, and I'll try and clarify those, and I'll also give you some tips along the way. So let's get to it. The three most common types of drunk driving convictions and or charges are 1, operating while visibly impaired or impaired driving, 2, operating while intoxicated, and 3, operating a motor vehicle with an alcohol content of 0.17 or more. That's commonly called super drunk and or operating with a high BAC. But before we can get into the specifics of the consequences for each, we have to understand some terminology that the Secretary of State uses. The first thing we need to understand is if they say your license is restricted, what does that mean? Well, it means it's restricted. It doesn't mean that you can't drive at all. It means you can drive your vehicle under certain restrictions. And so I'll go over those later in the video. 2, suspended. When the Secretary of State says your driving privileges are suspended, that means you can't drive at all. That means no driving. When I'm explaining this to clients, I say, hey, there's a hard 30 or there's a hard 45. That meaning that there's a hard time period where you cannot drive at all, according to the Secretary of State. And 3, I mentioned revoked because the Secretary of State uses the term revoked. We won't use it here because revoked is specifically for higher level drunk drivings that we're not going to talk about, or repeat offenders. It means you cannot drive, your driving privileges are revoked, and you can't get them back until you go to the Secretary of State and prove to them by clear and convincing evidence that you're safe to drive. That is a whole nother issue. For our purposes in this video, we're going to be talking about restricted driving and suspended driving order. The first one we're going to talk about is impaired driving or operating while visibly impaired. Out of the three that we're going to talk about, operating while visibly impaired has the least serious consequences from the Secretary of State. They will take action against your license. They will restrict your driving privileges for 90 days, and they will add 4 points to your driving record. Now, they will send you a writing and tell you when that 90 days begins and when that 90 days ends. And they also tell you exactly what the restrictions are on your driver's license. I'm going to read from the statute what the restrictions are, but I caution you to read what the Secretary of State sends you and adhere to what your specific driving restrictions are. After you complete that 90 days, all things being equal and you haven't driven outside of your restrictions, the Secretary of State will give you your full driving privileges back. All right, so out of the statute, it indicates that you can drive on restrictions in the course of the individual's employment. It also indicates that you can drive to and from any combination of the following: the individual's residence, the individual's work location, and alcohol, drug, or mental health education and treatment as ordered by the court, court hearings and probation appointments, court-ordered community service, an educational institution at which the individual is enrolled as a student, a place of regularly occurring medical treatment for a serious condition or medical emergency for the individual or a member of the individual's household or immediate family, alcohol or drug testing as ordered by the court, and an ignition interlock service provider as required. We'll talk about ignition interlock later, but those are generally speaking the restrictions that apply. And again, I caution you to read the restrictions on your order from the Secretary of State and comply with those. This brings me to the first misunderstanding and or myth regarding drunk drivings, and that is an impaired is not a crime. It is a crime. This comes up all the time when people come into our office and we ask them about a criminal history and they do not tell us that they have an impaired, even though they do. I don't think they're lying to us or trying to deceive their lawyer. They've just been under a misunderstanding, think that it was reduced, therefore it's not a crime or it's a civil infraction. Well, it is a crime. You can go to jail for it. You can be put on probation for it. If you get a subsequent drunk driving, it can be used to essentially habitualize you into a second or even a third drunk driving charge. So impaired is a crime. The next one we need to talk about is operating while intoxicated. Now, as far as the driver's license goes, the operating while intoxicated is a little bit more severe than the operating while impaired. The Secretary of State is going to take action. They're going to tell you in writing that you cannot drive for 30 days. It is a suspension, what I call the hard suspension, no driving for that 30 days. Then after that, there's going to be 150 days where you can drive with restricted privileges. Again, they're going to be the same likely as I read to you in the driving while impaired portion of the video. But again, I caution you to look at the restrictions that the Secretary of State sends you and comply with those restrictions. Now, the Secretary of State is also going to add 6 points to your driver's license, and that brings me to a tip that I would like to share with you. The tip that I want to discuss is knowing what's on your driving record. When somebody comes into our office with a driving-related offense, be it a drunk driving or something else, we always pull their driving record because the points stay on your record for 2 years. And if you get 12 points in 2 years, the Secretary of State is going to suspend your license for a year. So it's really important. And on an operating while intoxicated or an operating with a high BAC, you're going to get 6 points on your license. And that's a lot. As a matter of fact, that's the most points that the Secretary of State can put on somebody's license at any given time for one event, essentially. But if you accumulate 12 or more over a 2-year period, then they'll take action, like I said, and suspend your license, a hard suspension. So it's really important to know what's on your driving record. And if something's going to fall off, sometimes we can time it so that we wait till that falls off before a conviction enters. And sometimes that will save that extra severe consequence of that long-term suspension because of points. So that's the tip. Be aware of your driving record. There's another myth that I wanted to dispel or a misunderstanding that I wanted to clarify. And that is many times clients come into the office and they say, hey, I've been charged with drunk driving, I can't drive. And I look at their driving record, everything else is fine. They don't have points on their license. This is a drunk driving first. Prior to the interaction with the officer, they didn't have any criminal history and they had a valid driver's license. All those things being true, you can drive. After the interaction, if you go to jail, after you get out of jail, you should have a pile of paperwork. Amongst those documents should be a temporary driving permit. And we'll post that on the web page so that you can see what it looks like in case you didn't get it. But with that, you should carry it with you. You should carry a photo ID with you. You should be able to drive. You should be able to drive until and unless you are convicted of a drunk driving. If you are convicted of a drunk driving, again, people ask, well, I've been convicted. Can I drive home from court? Yes, you can. At the court hearing, at the court date, if you are convicted by a jury or you plead guilty, the Secretary of State is going to get an abstract from the court saying, hey, this individual was convicted of drunk driving. That will trigger them to send you a document telling you what your driving restrictions, suspensions, what that is, and they will tell you a date when it starts. So you can drive up until then on your temporary driving permit. Then you can't drive, or you have to drive under the restrictions that apply to you until they end. Then you'll have to pay a reinstatement fee, generally speaking, to the Secretary of State. But then after that, generally, you'll get your full driving privileges back. So all things being equal, you can drive on that temporary driving permit. And if you have a lawyer, make sure you're communicating with the lawyer so you're on the same page with your driver's license. The third type of charge that we need to talk about is that high BAC, or driving with a BAC of 0.17 or above, commonly referred to as super drunk. Now, out of the three that we're talking about today, this has the most serious consequences on your driving privileges. The Secretary of State will take action, and they're going to suspend your driver's license for 45 days. Again, I call this a hard suspension. No driving for that time period. After that, for 1 year, you're going to have the ability to drive on restrictions. Same restrictions as the impaired or the intoxicated driving. You'll get notice from the Secretary of State. They will detail those restrictions, so pay attention and don't deviate. The kicker, though, is among those restrictions is you are going to be required to install a breath alcohol ignition interlock device in your vehicle, commonly called an ignition interlock or a blow and go. It's a device that is installed professionally in your vehicle, and you have to blow into it every time you drive. In order to start that vehicle, you got to blow into the machines. Now, these are complex machines. They have a camera, so it witnesses you, so you can't have somebody else blow into it. The machine is going to detect alcohol at a level of 0.025 or above. And for context, a standard OWI, or operating while intoxicated, is a 0.08. Now, this is significantly below that. A lot of the machines now also have GPS in the devices so that they can tell if you're driving out of restrictions. So you got to be careful. It is a very intrusive machine, so you want to avoid that if possible. This ignition interlock can be very tricky, and we really need to do a whole video on ignition interlock. So hopefully we can get that done for you. But for now, just be careful, be aware of the rules, follow the Secretary of State's instructions on this, because it can be complicated and it can tangle you up. So, final piece of advice: if you're driving on your restrictions, make sure you carry, something in writing. Maybe it's on your phone these days, that is proof of where you're going, where you live, that you're going to and from work, you're going to and from school. Because the consequences, if you get caught driving outside of your restrictions, or if you get caught driving while you're on a suspended driver's license, you can get a ticket for that. And it is a crime as well. But if you get convicted of it and the Secretary of State finds out about it, they're going to do what's called a mandatory additional. So whatever suspension restrictions you had, they're going to do it again. So you just double the time frame that you're on those restrictions. And it just sometimes creates this cycle that you don't get out of. So make sure you read the Secretary of State's written restrictions, you follow those to a T, you keep proof in your car of where you're going at all times, and you should be all right. Stay safe out there. I hope this helped.